you guys haven't had a chance yet to grab a folder, in it you will find a paper copy of the notes, the slides. You also find some information from NCMIC. This lecture, so we wanted to get someone in who has experience sort of in the malpractice industry. We reached out to a couple different companies. One took us up on it to come in. So I just want to acknowledge that NCMIC is a vendor. They are a company that sells malpractice to naturopaths. For a while, they were one of the only companies in the game, sort of early on. They started out as a company that covered chiropractors when no one else would cover chiropractors, and then they since branched out to other types of providers. So anyway, they ended up flying Jackie Hellrung out from Iowa to meet with us, but could only choose one section to go to, so she chose Monday. And we tried to negotiate with her about how we could share that with the other section, and it was a little bit fraught. They did not want it recorded. I managed to get them to accommodate a recording as long as I signed a contract specifying that it would not be posted, that there would be zero chance that it would be copied, and which meant I would have to play it off of my camera through this and this sound system to you guys. So I did that. I recorded it and I tested it, and it was just, I'm not going to subject you to that. It was going to not, I mean, even though it would have reproduced what was, what was experienced on Monday, it would have done so in such a frustrating and annoying way that I am just going to cover the content. And I hope to, I have a fair amount of experience with malpractice. Personally, I attended the lecture, I reviewed the slide, I understand what she presented, and I can do that. And I just want to keep it dynamic, because I think the vibe from the other section was one of a lot of trepidation. And I think this is the risk of this class, is that we're constantly kind of piling on more and more things that you guys need to worry about. And that's not the intention of this class. The intention of this class is to actually reassure you, to give you structure, resources, some context, and overall, like, a sense of hope that this is not a system that's geared to constrain you or punish you. It's a system that's designed to keep order. So in any event, I'm going to give this lecture today. And in addition to not really wanting us to record, she didn't want to provide us a copy of her slides. So this is a scan of the thing you guys have. Wow. In any event, so okay, so here we are. We're going to talk about malpractice today. I want to give sort of a broad overview of what malpractice, why you might have malpractice insurance. What are some things to think about as a potential consumer of malpractice insurance? How to navigate policies, how to think in advance about the ways that you'll utilize or relate to the companies that provide this insurance. And then talk a little bit about risk management, how to avoid falling into harm's way as far as malpractice goes. I'll say, just full disclosure, so at Bastyr, I am covered by a sort of a institutional policy. I forget the name of that one, but it's not NCMIC. I also have insurance via NCMIC in my private practice, and I have no there's no financial interest in this talk, nor do I have any interest in steering you in one direction or another towards a given company, even though what we're talking about here are things provided by NCMIC. It just provides a basis to frame how you guys are going to approach the decision of who to go with, or if you want to go with any insurance. Okay, so what is malpractice? Not insurance, but what is malpractice? There's a few elements here that go into a claim or an allegation of malpractice. Okay, so These four things need to be in place for someone to have a viable case against a practicing provider. First, there has to be a duty. So this is the doctor-patient relationship. You must establish a relationship where you have an agreement with this party. Okay, that could be absolutely formalized in the course of them coming into your office, signing your forms, establishing that relationship formally, you establishing a chart with them. It can also be established somewhat informally, and this is something to be aware of. If you identify yourself as a doctor and someone approaches you in that role and asks for your advice, it can be construed that you have established a doctor-patient relationship, but you've done so in a way that may put you at risk because various informed consents and other things have not been established. But that's step one. Step two is that there's a duty that's owed, but step two is that there's a breach of that duty. So some part of the agreement that generally goes into providing that service has been violated. That could have something to do with standard of care, or a set of professional expectations, or gross negligence. We'll get into some of that later. Then, owed a duty, a breach of duty, and then there is an injury caused by that breach. Okay, so not just that you failed in some part of your agreement, but that led to harm. Okay, that also has to be established. And then in general, that kind of segues into whatever damages would be assessed or sought. There are a handful of different types of cases that you'll see. These are the most common. Failure to diagnose, so either delay in diagnosis or treating people symptomatically without characterizing their condition accurately or giving them information about prognosis or the pathophysiology. That's a very common one. Lack of informed consent, failure to document or get informed consent. There are various permutations you can imagine of this, but essentially, like if you are proposing a treatment path for a patient, whether it's a procedure or a set of medications or a protocol, you want to make sure that you have both provided this information to the patient about what is the procedure, what does it involve, what are the risks, what are the alternatives, answered their questions, and then documented that. And so those two things have to happen. It has to have occurred, and it has to have been documented. That segues into the next type, where there's poor documentation or record keeping. This is usually kind of a secondary problem when it comes to malpractice, because if someone alleges that there was a breach of duty and harm, your best defense is what? Your chart. So the record keeping is important. It has to both be accurate, it has to reflect good care, and it has to have integrity. And when we say integrity, it means that you have protected it and it's a credible record. It's not like you haven't ever signed a chart in your EMR and every record is open and you could change anything at any time and no one could ever know. That would obviously call into question every single one of your charts because it's not credible. Adverse reactions to supplements. They were talking about this kind of absurd example of a patient with prostate cancer was given up some sort of bull testosterone extract to help with the prostate problems, and the patient claimed that the testosterone fueled rapid growth of the tumor. So, it's like, just like Dr. Gilden said last week, you may get experts on either side of that, but that's one where, your use or choice of that supplement and its contents, you would have to be able to defend that. Okay, so if those are the malpractice kind of risks, you as serving your community have a duty to uphold patient primacy, patient safety, all those things. And if someone feels like you didn't do that, they can bring a malpractice claim against you. This is why you have malpractice insurance. Okay, so malpractice insurance is going to come in lots of different sizes and shapes, just like any insurance you might get: homeowners, car insurance, health insurance. And what you want to do is you want to make sure that when you are evaluating it, you really understand the coverage. You understand what you're getting with your policy, with your money. So in particular, like scope of practice, like you have to know your scope of practice for your state so that you are adhering to the rules of your license in that state. You also have to make sure that what you are doing in that scope of practice is covered on your policy. So for example, some policies might be less expensive because they choose not to cover IV therapy. And if you provide IV therapy, you have a blind spot there in terms of your coverage. Some might say we're not going to cover care of infants under 2 weeks old, even though that's in your scope to take care of that newborn. They'll say that's too risky, we're not going to cover that. So if you don't see less than 2-week-old babies, that's no problem. But you just want to know that that's even if it's in your scope of practice, it may not be in your coverage, and that's what's called an exclusion. So some insurances will require you to then sign up for a separate kind of rider or a separate feature of your plan to cover the specific things you do that might have an elevated level of risk. And then you've got coverage limits. So this is like the amount of money that you are covered for. And there are a variety of different kind of levels, tiers we'll get to in a second. All right, there's two main types of coverage. And this verbiage starts to get a little bit strange, so just bear with me. There's claims made coverage, and there's also occurrence coverage. So claims made coverage means that it offers protection to you for claim. If the claim occurs while you have the policy, you're good. Okay? So now we'll get into a couple examples of that in a second. Now, if for example you have, however, a policy, you go, you work in a clinic for 4 years, and then you decide, and you have sort of insurance coverage those 4 years, and then you go on to move to a different clinic, and you decide to get a different insurance. And say a claim is made at 3 weeks after you cancel the first policy. A claims made policy will not cover that, even if the alleged event happened when you were covered. Does that make sense? So the coverage applies to when the claim happens. It also obviously has to happen within the time where they were covering you, but there's this statute of limitations where even if you cancel a policy in the state of Washington, for example, there's a 3-year statute of limitations where you have to file a claim if you allege there was a harm done by a physician, with the caveat that if it's a child, it's 3 years from the date of age 18, I believe, and there's also this other minor caveat where if the patient didn't realize they were harmed until later, it's 3 years from the date that they realized that there was harm. So with those caveats, there's this window of opportunity where you could have done the bad thing, or the bad thing could have allegedly happened, and the patient doesn't file a claim for 3 years. So there's that gap where you would want to make sure you have some accommodation. And if you do transfer to another insurance company, you then may have to buy something called tail coverage, which is essentially, the tail is like the coverage that goes down over time for those any and all claims that could be made after you leave. And some companies will do this thing where they'll offer you, if you have 10 years of continuous coverage with no claims, they will essentially give you free tail coverage if you leave. So there's like an incentive there to stay with one company for longer. Typically, when you sign up for claims made coverage, it's cheaper at the onset because you don't have any patients, So there's not a very low likelihood of you getting sued. Now that will go up over time as your panel of patients grow and you've got this sort of shadow behind you of all the patients you've served, and who knows what's going to happen back there. But that escalates to the point of, I believe, 6 or 7 years, and then it stabilizes. Okay. So for example, an ND who comes out in Washington, I think Jackie quoted something like, for a year of malpractice, when you come out, it's about between $600 and $700 a year, which is quite reasonable. Now that will go up, and but it goes up to a reasonable amount. We're talking about maybe $2,000 a year, depending on the sort of structure of your practice, the density of your patients, the number of patient hours you have, which is like 50% less, if not more, than most other primary care provider types. Which is, I think, a good illustration of the fact that we are a low-risk population to insure, which is great. And that bodes well for you. This is the hope part of the talk. Okay, so here's just a couple examples for, like, you purchase the policy, here's the incident happened, the claim is made in year 3, you cancel the policy. Here the question is this covered? And a claims made policy. Raise your hand if you think yes.
Claim was made.
So you have the coverage from here.
Yeah.
The incident happened here, the claim's made here.
Still covered.
You're good, you're good. All right, how about this one? Purchase the policy, incident happened here, cancel the policy, claim is made.
No.
No. Okay. Good. Now, if you have tail coverage, it's fine. So that's the purchase the tail coverage, and then that is taken care of. Here's a little promotion for discounts that happens. Okay, so limits of liability. So you're generally going to have 2 numbers associated with any claim. And what those numbers reflect are, what is your coverage for any individual claim made against you? And then what is the aggregate if you have multiple claims for the total coverage you would have, and this is in any given year. Okay? So the example here of a 1 million, 3 million policy would be that any individual claim would go up to a maximum of $1 million of coverage, and you could have a maximum of 3 of those per year and get $1 million of coverage for each.
I bet your premiums wouldn't stay the same.
True. And not just your premiums, but probably the whole community's premiums, because it's pooled money. You know, I have certainly seen in my career there have been at least one high-profile malpractice settlement that definitely caused my malpractice to bump up, even though I didn't have anything to do with it. So we have a responsibility to one another in this as well. So now, how do you choose limits? Like, these are some common breakdowns. You could have 100,000, 300,000, 200, 600. You know, it could go up. There's actually, you can do 3 and 5 million. I think that's what the best year institutional policy is. The difference between these, the cost of these is pretty negligible, and most of the time what you're going to want to use to dictate your level of coverage will be the requirements of the insurances you credential with. Let me say that again. When you credential with insurance, they are going to want you to demonstrate proof of many things. You passed your boards, you have an active license, you have a background check that's clear, and you have malpractice coverage at a minimum of this amount. So in Washington, it's 1 and 3 million, depending on your specialty. So that's what I talked about, I think, a few classes ago when I said, you know, most people have malpractice insurance to get in on health insurance networks because it's a requirement. I think it would be a lot more of an introspective kind of existential question for providers to ask themselves, do I want malpractice coverage if I didn't have this requirement? How do I feel about liability? How do I feel about my patient relationships? How do I feel about this? You know, the truth is, as I alluded to, having this coverage, that is like chum in the water for sharks, right? You've essentially got most malpractice attorneys, when they take claims from patients, they'll say, what was the alleged harm, and by the way, how much coverage does the doctor have? Because that's what we're targeting, and there's a cost-benefit analysis to bringing a lawsuit against someone who doesn't have malpractice insurance, because there may be a limit to what you could plausibly get. But if you have a massive policy, then the calculus is different. Yeah, question?
Well, I'm just going to say, and I think also it depends on how you set up your business, because you can protect your personal property from that liability by the way you set up your business. But if you're a sole proprietor, then your personal property becomes...
Yeah. So I mean, like I think some of that is true. You want to be mindful of how you set up the tax structure of your business and whether there's true separation between personal and professional. I'll say this: you can't use businesses like burner phones, where you're just like, I'll just dump that business and I'll move on. Like, they can still come after you in various ways, and there's civil courts, and there's all, like, so I don't want you to feel that you can somehow completely insulate your personal liability just via a clever tax structuring. But it is true, to be mindful of that will certainly add in a layer of protection. Yeah?
I think you mentioned a few classes ago that if we are wanting to be under insurance, that insurance requires us to have malpractice insurance. Is that accurate?
Yeah, that's what I was just saying, is that's why most people will sign up for the insurance, is because in order to apply to be in network with any insurance, they will ask you for proof that you have not just insurance, but this level of insurance. So when you're shopping for malpractice, first consult the networks you want to get in on to make sure you're finding a policy that satisfies their requirements.
Do all of them across the board require malpractice insurance, or are there certain insurance companies that don't?
I don't know of any that do not. And this is because, if you think about it, the health insurance networks are trying to provide quality for patients. And so if you're trying to provide quality for patients, you want licensed providers who don't have, who aren't fly by night, who aren't going to exploit people, who don't have a bunch of claims made against them, and have coverage in case something goes wrong. Okay. So here's an example of how NCMIC structures this. Even though you have those coverage limits, you kind of want to know what counts towards that limit. In particular, you want to know if the defense fees are applied to that, or if they're separate. And so NCMIC is quite proud to announce that their defense fees are not part of that limit. So if you have a $1 million limit for a claim, and it's a lot of defense that needs to be mounted, the fees for the attorneys could be $500,000. It could be a lot. It could take out a huge chunk of that. But they're saying we defend outside of those limits, and we, obviously have our own incentive to defend you adamantly. So we're just going to take on the expense of that and not really worry about whether it's taking out from your particular claim limit. And that includes things like the attorney's fees, expert witness fees, paying people like Jane Gilton to be on your side, travel expenses, and this stuff is not cheap. Dr. Gilton did not really allude to this, but when you're talking about an expert witness, she says you get paid well. They ask you for your fee. So if you were going to be an expert witness in a thing, they'll say, are you willing to do this, and what would you, how would you kind of land on it as far as a determination, and then what shall we pay you? And there's really no questions asked. So I've been involved in some of those proceedings. I've been an expert witness. I've been deposed in claims, and some of the people around me, expert witnesses, have charged upwards of $1,000 an hour because they are a surgeon and because their hours are spent in surgery. And so they're basically saying, if you want me to take an hour to be in a courtroom, you're taking me out of the surgical suite, and I honestly would be making probably $4,000 an hour. So let's call it good at $1,000 for this hour. So a little sidebar on that, my experience with malpractice started really early. I was a resident at Bastyr first year, and I was being deposed for a claim. This was is a weird scenario, but I'll just digress for a second and tell you the story. I was a student back when we were writing paper charts, and I saw a patient in patient care where she had come to us at Bastyr after having had a football-sized lipoma removed from her pelvic sort of abdominal area. And in the removal of that massive lipoma internally, the surgical team accidentally or inadvertently severed the femoral nerve. And they recognized it right away because it was a lot of blunt dissection, it was a lot of complicated surgery. Reading the surgical notes felt like watching a TV drama or something. It was like harrowing to see. They talked about, blunt dissection involved these structures. Then we realized there was the nerve was severed. We immediately paged the neurosurgical unit. They came in to re-anastomose the two segments and put it, it was a very interesting read, but the patient basically came out of that with some pretty significant weakness in one leg. It wasn't completely paralyzed, but it was weak, and she had numbness, and there was a bit of pain that was kind of, she alleged was related to that problem. So I was seeing her as a student, and we were writing paper charts, and our plan for her was this comprehensive plan involving like TENS, E-stim, B12 shots, homeopathy. We were doing exercise and rehab, and I happened to be the only student clinician in her care with the Bastyr system that had legible handwriting. And so when this patient later decided to sue the hospital for negligence in severing the nerve, the hospital's defense subpoenaed or deposed every single person they could find that participated in the care of this patient. So when they requested records from Bastyr, they looked at this chart that was massive. They couldn't read anything except this one pristine set of notes from a Christian Dodd. I put my whole name, like I was very perfectionist in my charting, and anyway, so as soon as I got this certified letter, deposition, requesting the chart notes or whatever, the first thing I did is, take it to the clinic medical director. Oh God, I'm really scared. Okay, what do you think the first thing the medical director does? So the first thing you do when you get anything like that, whether it's a claim against you or you're being asked to participate in a claim or there's a board action, call your malpractice cover. Because they are there for you. Like, they have an interest in what's about to happen, and they have lots of legal resources. They have skin in the game. They are part of your team. And so he called them. What do we do? And so then they guide you through. First of all, most policies require that you do that within a time frame. So if you sit on a certified letter that alleges you did something wrong, if you sit on that for a week, some malpractices will say, sorry, you're on your own. You delayed in telling us about this. So make sure you read the policy really carefully. Some of them will have a 24-hour window, a 48-hour window, when you have to give notice that you have been served. So anyway, we called them, and the first thing they said was, cooperate, 100%. And we've got an attorney on our way right now. So they send out a fancy attorney to meet with me, brief me on what this all means, review the records, all this stuff. And it was great. Like it felt like it was like concierge service in this really, kind of scary time. Even though I wasn't being alleged to have done anything wrong, I felt like the stakes were high and I could really mess this up. No one trained me in this. So I'm going through the process. He's like looking at my notes and he's kind of like chuckling about how good the handwriting is. He's like, some people would say you did yourself a disservice by making this so legible. But he was joking, of course, because you want legible handwriting, because if it's illegible, you don't have credibility. And then he's like going through, he's like, they're going to depose you. There's going to be 4 attorneys on this side, a court reporter here, 4 attorneys over here. I'll be on your side here, and all eyes will be on you with a microphone and somebody transcribing every word you say, including ums and I don't know. So it'll be stressful, but you'll do fine. Just don't overthink it. And by the way, tell them what your fees are so that they can pay you for this time. And I'm thinking as a resident, I'm like, okay, well, probably by the hour I make about $20. And so I said to him, I said, what about like $50 an hour? And he like seriously spit up on himself with delight. He was just like, so anyway.
That was a little low, I take it.
He was a little low. It was a little low. Anyway, the interesting. I'll just follow through with that story. They were very interested in my chart note because, and this was a lesson for me also in charting and kind of prognosticating. I was full of optimism as a student, and I was quite, I was empathetic of the patient's plight for having the femoral nerve severed, but I felt that if we put together a structured plan, I had like 6 B12 shots, once a week, once a week for 6 weeks. We were going to do E-stim twice a week for 6 weeks. We were going to do homeopathic hypericum and all these other things. And essentially what they did is they looked at that prognosis that I put in. And I said something like, if, our hope is that if the patient performs these 6 and these 12 treatments, that we will recover muscle function. And so these fancy attorneys for Swedish Hospital are coming in and saying like, can you read this line 27 of page 200 of the chart? And I'm like, if the patient does 6 B12 shots, the hope is that they will recover nerve function. And I say, okay, now can you just review the chart to see how many of those the patient actually did? And I looked through it, it's like, well, she did 5 out of the 6. And they're like, oh, so you're saying if she had done 1 more, she would have been fine. And I'm like, well, that's not exactly what I was saying. But can you read line 27 again? Well, I said if there was 6, we hope that, So it was like this kind of thing where it's like, of course, the attorneys for Swedish Hospital don't believe B12 shots are going to fix a severed nerve, but they're looking for a foothold, right? So this is the kind of thing that, like, early in my education, I realized you gotta be careful in your chart. It's like you don't want to overstate a positive prognosis, because that ultimately can come back and you would have to answer difficult questions if it doesn't come true. You also don't necessarily want to hedge all your bets and not say there is any basis for your treatments, because then that could also come back to you. So there's this professionalism kind of, I guess, sort of lingo you would use, or kind of like a way to communicate your intentions with a patient while also acknowledging the uncertainty of patient care, the uncertainty and autonomy that patients have. Yeah.
Yeah, so when you aren't certain, like something like that where it's truly like experimental, like maybe it'll work, would it be in a better interest for you to chart like in 6 weeks we will reevaluate?
Totally.
the efficacy
100%.
Instead of saying I'm hopeful?
Yes.
Okay.
And say something like, our goal is to recover as much nerve function and muscle function as possible, though the prognosis is uncertain. And our plan is to do this number of treatments with this set of goals, which we will reevaluate at this timeline. And they could still go back and say, well, this was a non-compliant patient, and try to paint the picture of this patient undermined her own care because she was flaky about following through. But that's not my problem, right? Like I'm not there to defend that. That's sort of the jury's responsibility. I at least feel I wouldn't have awkward questions to answer in a deposition, When I went through this talk as a student, we had an attorney come up and give the talk, and their advice struck me as totally absurd. But it is advice you will hear, where they say, they kind of put up one of our chart templates, like in that day it was like the piece of paper that we would do the chart on, but in this day it would be like the EMR template. And they say, this is your chart template, right? You guys recognize this? They're like, well, here's how you should think about it. And then he puts in at the top in big font, ladies and gentlemen of the jury, ... And then everything else. I don't think you should practice with that kind of paranoia. But I think you should start to envision, how would it feel to have a patient read this chart, to have a patient's attorney read this chart, to have adversaries read this chart, to have, just, again, not to make you crazy defensive, but just to say, I want to provide a document that feels good under all those circumstances, and it's possible. Okay, so a couple other things to think about malpractice insurance. There are these other clauses, or you can talk about like endorsements. Some plans will give providers consent to settle. Does anybody want to speculate about what that means?
You can decide to settle.
Versus what?
Letting the process carry out and the insurance company make a decision on that. You can make the decision yourself and say, I'm just going to settle.
Yeah, so it tends to be like when you are accused of something you didn't do or you feel is defensible, the providers in general will want to defend their name and will want to fight. Insurance companies have no real interest in doing that. They want to minimize their expense. So oftentimes there's this conflict between the insurance's interest in settling to just be done with it, minimize costs, minimize legal fees, minimize exposure, and know what you're going to deal with, versus the provider's interest in protecting their good name, which means I don't care how much it costs, I want to fight it all the way. So some plans will actually not allow the provider to participate in that decision. They'll basically say like, look, our legal team has determined that we're going to settle this. Sorry, it's our money, you know. But I think what you probably want to do is not abdicate that responsibility. So this would be a consent to settle, would allow you to be in charge of that decision ultimately. They may pressure you, or they may provide a lot of sort of, you know, advice on that, but you still would have ultimate control. You know, different kinds of like, these are other things that you might look for, like broader coverage for minor surgery. You'd have coverage for locum tenens, so if you decide to go on a sabbatical for a couple months, you could actually have another licensed provider come in and cover your practice under your insurance. So that's kind of a nice feature, but it just means that you cannot be practicing elsewhere. So that has to be like a true kind of one-for-one substitution for a short amount of time. People will do this for maternity leave, or sometimes if they're recovering from an injury or a surgery or something like that. It's pretty useful. And you also get some, you know, where you can get dual license coverage. Those are good to look for. So she gave a few examples, just like, you know, here's an example with an ND who has lower coverage limits, 100 and 300,000. There's poor documentation. This is someone who was treated for a long period of time, 5 years, without ever referring for additional workup. So someone who was treated for pain for 5 years, it was repetitive treatment, the documentation was poor, and that every chart note looked kind of the same kind of HPI, the same kind of PE. It was just like this routine, and eventually it was found out that the patient had cancer and the pain was related to that cancer. And so this is a problem. Like, this is gross negligence, and it doesn't look good as far as the defense. And so this was an example of a possible verdict. You know, you've got the medical expenses over those 5 years. You've got future medical expenses, wage loss, future wage loss, pain and suffering, a total claim of over $1 million. And this is something where your coverage limits of $100,000 would leave a substantial amount of that to the doctor. Now, I want you to recognize that is gross negligence. Okay, this is not something that you accidentally just space on one day. I mean, this is 5 years of repetitive, massive blind spot where there should have been all kinds of systems in place to say, am I sure about what I'm dealing with? Is this the right management? Should I refer or at least get another image or something? Okay, so if you get a claim, this corroborates exactly what Dr. Gilden said. Don't panic. Call immediately. You call immediately to start the ball rolling. You'll want to give them written notice that you've had a claim against you or you've been served in some way. And then at that point, absolutely do not try to change anything you have done. And this is where the point was made many times that the defense attorneys who are there to protect you can defend you for almost anything. Almost anything. They can do nothing to protect you if you went back and changed the records after you were served. There is no defense for that. So even if it looks bad, even if you feel self-conscious about certain parts of it, keep the record credible. Keep the integrity of your chart in place, because at least you will have that to bolster your own sense of integrity, which is what you're going to be leaning on in a case like this. Are you a doctor of integrity? Are you a professional? Yeah. Okay. She had some funny cartoons. I was warned about the clauses, but I didn't listen. Let's see. Consent to settle, we talked about that. Arbitration clause. Some insurances will try to put in things like, have you guys ever seen this? Like, this is a deal with employers. This has gotten a lot of attention recently with sexual harassment. That certain employers will make potential employees sign an arbitration clause when on employment, that they will give up any right to a legal process with a judge in favor of arbitration if there are any complaints like that. And it's basically a violation of their rights. But it's also something that they are able to decline, but then just not be employed by this person. So it's this massive power dynamic, and that stuff hopefully is changing. Some insurance companies will want you as a doctor to use arbitration to your advantage and essentially mandate that you make patients sign arbitration clauses before they establish with you. And it's essentially kind of like another form that they fill out where they say, if anything were to happen, I waive my right to a judge or jury trial in favor of arbitration, which is binding and neutral. It's kind of like, if you could imagine being a patient and like one of the first forms is basically saying, by the way, in order to see me, there is no legal protection for you other than arbitration. It feels adversarial. It feels almost like hostile, to that patient's rights, their patient's autonomy. So you want to be wary of plans that are going to ask you to do something that could be perceived as hostile to your patients. Even if it might be like a liability control thing, you still have to be in charge of your professional relationships with your community. And that's one that I think pushes the boundaries. So you're giving up the option to go to court. Now, there are other clauses. The one's called a hammer clause. This is one that kind of is a corollary to the consent to settle, where if they offer a consent to settle, a true consent to settle, to the doctor, but then they also have a hammer clause, what that means is that the doc might say, nope, I refuse to settle, we're going to fight this all the way. But at that point, the malpractice liability or their coverage would be limited to whatever the settlement amount was. So this is a way for the malpractice to kind of give the doctor some element of control in how they proceed with cases, but also limit the amount of exposure they have, where if there is a dollar figure on the table that the insurance company says, that's a good dollar figure, we should take that, and the doctor says no, then all of a sudden that becomes the limit of what the insurance company will pay for that, because that's what they were offered and that they didn't have a chance to actually take it. Questions? I think it's underappreciated that your malpractice company is a great resource. They have an interest in prevention. They have an interest in giving you lots and lots of legal advice to make it so that there's a less likelihood of a claim, or that if there are claims, that they're tidy, that they're easy to defend. So if you go to NCMIC site or any site there were a couple other on the Moodle page, other companies that offer malpractice plans. If you go to their websites, you will often find tons of free resources. Everything from forms, informed consent forms, policies and procedures, discussion about topics around malpractice, patient boundaries, social media, blogs, interacting with people in the public. So, you know, as you go, like, you know, think about just, you know, some of you have brought a lot of questions, like, how do I know, like, you know, where to find the state licensing board at the state that I want to practice in? Well, guess what? NCMIC has a definitive list on their site because they want to make sure all the docs who they're covering know exactly where to find the scope of practice in their state so that they have the maximum ability to adhere to the law. A couple of risk management strategies were discussed. Documentation is number one. Accurate, complete, timely, readable, honest, professional. We used to talk all about like how to make sure that you aren't adding, if you're using ink and paper, it was like a lot of measures to try to make sure people weren't adding in pieces in the margins or like altering the record. Now in EMR, honestly, it's about the credibility of the record from a cut and paste standpoint and a proofreading standpoint. So be aware, you know, like having a chart that looks the same visit to visit, where lots and lots of parts of the patient's chart are just carried over visit to visit, does not lend itself to you being a very informative documentarian. You know, you're not essentially providing anything new. So is this all just repetitive and cut and paste? Making sure you're closing your charts on time. You know, there's policies in place you guys know about as far as clinic, getting the chart to your supervisor so the supervisor can close it. Making sure everything's proofread is important. I'm not going to go over these red flags because I think a lot of them are anachronisms at this point. Definitely don't alter records. She gave an example of something in the EMR where it's like there are certain alerts for a given patient, and if the patient sort of, in this example, a doctor essentially altered the alerts that came up for a given patient around diabetes management after a claim was made, because the claim had to do with diabetes mismanagement, and so they wanted to kind of minimize the fact that they were repetitively being alerted about diabetes mismanagement in the chart. You can audit that down to see when that was turned on or off, and they were able to identify that that was turned off after the claim was made, which again totally brings the whole rest of the chart into question. HIPAA compliance is a big one. The biggest thing I think that you guys are going to come into, and maybe you already have waded into these waters. One, you have a lot of advantages because of the doctor-patient relationship. So patients don't sue doctors they like. Generally, they don't sue doctors who are empathetic and humble and personable. And this is part of our ethos, right? So we have an advantage there. This is why I think our rates of malpractice are so low. Not because we're so perfect in our management of every patient or that we never make mistakes. It's that our mistakes when they are made are more forgiving and more forgiven. Hopefully that means you also are using those mistakes to make your practice better, to avoid repeating them. The thing that is going to be tricky, I think, given that kind of empathetic is are you putting yourself out there in ways that are pushing the boundaries? So do you potentially violate HIPAA with your interactions over, say, social media, or say on a blog that you post, or an article that you share? Like these are things that I think you want to think really carefully about. If you give any patient information in any public forum, that is a HIPAA violation, you know. And there's lots of people in our community that don't understand that. They think if I'm on a closed group on Facebook, or I can, you know, sort of have some kind of like, you know, private channel, even if it is relatively secure, if it's posted on some site where you don't know who's on there, you give patient information, that's violation. If you are, you know, a lot of people these days ask me about like building their brand via Instagram or other places where you give medical kind of information. Is that okay? What do you think about that? If I talk about how great, you know, whatever. If I say I talk about how great L-carnitine is for hyperthyroidism, and I write a big blog about that, and then someone tries it and something bad happens, am I at risk?
Kind of depends on what you said in that post.
What would be the reason why? What would be the reason that I would get into trouble if that was?
So there's no side effects or no risk.
If you're presenting it as medical advice.
Yeah, so attention, anyone with hyperthyroidism, I am now your doctor, and here's your treatment plan. That would get you into trouble. If you are not establishing, though, a doctor-patient relationship, back to that very first slide, in order to demonstrate that there was a breach, you have to have a relationship and a duty. If you are writing in the generic terms about information where there is no doctor-patient relationship, you are relatively insulated. Okay? Yeah?
Do you also protect that further just by writing a formal disclaimer?
No, I think that's appropriate to write a disclaimer, and that's why you see disclaimers all over the place. Every podcast that has anything to do with medicine has a big disclaimer. But fundamentally, the disclaimer is not the main thing that's protecting them. It's the lack of the doctor-patient relationship.
Because even with the disclaimer, if you're really making claims, even though you have a disclaimer, you can still be held accountable for the statements you made.
Exactly. All right, well, we're over time. If you didn't get a folder, grab one. One other announcement. It came to my attention that there's a glitch in my class page around the pre-questions and the post-reflections. I don't know what happened. So
They haven't been there for 3 weeks.
what I'm going to do, because we're sort of missed the window for the pre, I am going to post sort of a recovery one where I just want like a 1 or 2 nugget takeaway from the various talks that we've had. You can submit it as one thing, just to satisfy the requirement. Make it simple. Sorry about that. All right.
We're not complaining.